of last week's Supreme Court decision in the King v. Burwell case. We are fortunate today to be joined by Carmel Shakar, staff attorney at the Harvard Center for Health Law and Policy Innovation, and Scott Shadas, HIV Project Director and Senior Attorney at Lambda Legal. Before we begin the webinar, we do have a few housekeeping items to go over. All participants are in listen-only mode, but we encourage you to use the question feature on the right side of your screen to ask questions throughout the webinar. We will answer questions at the end of today's presentation. If you're unable to hear the audio, you can dial in using the telephone number and access code provided on the Audio Control tab on your computer. You can go to hivhealthreform.org to download the slides, which are featured in the home page slider. And we also hope that you live tweet during this webinar using the hashtags ACA and King v. Burwell. Our Twitter handle is @HIVHealthReform, and our Facebook is hivhealthreform.org. At this time, I will now hand it over to Carmel, who will begin today's presentation. Carmel?
Great. Thank you for joining us, everyone. This presentation is going to be a lot more cheerful and a lot more fun than it could have potentially been had the court ruled differently. But we're going to walk you through the King v. Burwell Supreme Court opinion that came out last Thursday that was really an incredible victory for healthcare reform. It sort of finishes the work that the 2012 healthcare case did to legitimize the ACA and make sure that these reforms are here to stay and here to help consumers in the coming years. So to give you an overview of what we're going to cover, so we're going to first discuss the background of this case. So why is it an issue? How did it come up? We're also going to do a dive into the legal analysis of the court's opinion to explain to you the nuances of it and why it's really, in a lot of ways, the best possible outcome we could have hoped for. We're also going to talk about the unique role of amicus briefs and the role that they played in influencing the court to have the outcome that we did. And then we're going to discuss next steps in healthcare advocacy because, as I'm sure all of you are very well aware, this was an incredible victory, definitely worth a very happy weekend for us all. But the work to make sure that everybody has meaningful access to healthcare is not yet finished, and we have a lot more to do and a lot more to ask for from the government. Next slide. So first, we're going to start with the background, how this case came about, what were the underlying programs that were at issue. Next slide. So the program at issue were subsidies. The ACA allows for individuals within a certain income range, 100 to 400% of FPL, to receive tax subsidies to help pay for health insurance obtained through the exchanges. So the idea behind it was if you are not quite poor enough for Medicaid, but health insurance would still be prohibitively expensive for you to afford, the government will step in with subsidies to help you participate in the marketplaces so that you can get health care. This is especially important for this population because this is really, in a lot of ways, the working poor, and statistically, their jobs are much less likely to offer some sort of employer-based health care than higher-paying jobs. So as you can see, the income range is pretty low. When we talk about 100% of FPL, for a household of one, we're talking about a little bit over $11,000. When we're talking about 400%, it's a little bit over $46,000. So especially depending where you live, that doesn't get you very far at all, especially at the lower range. A household of four, it's 100% FPL, is almost $24,000. 400% of FPL is a little bit over $95,000. And so, again, I want to emphasize that in some ways this is different than when the Supreme Court, politically this is different than when the Supreme Court looked at Medicaid expansion, because this is a group that is more politically enfranchised than the group that typically receives Medicaid. So it's a group that votes, which made politicians a little bit nervous about the ramifications. And it's also a group that has been receiving these subsidies for the last couple of years. So the way the subsidies work is that if an individual qualifies, they don't get a flat sum. but it's a sliding scale. So they won't ever pay more than 9.5% of their household income for their coverage. And the amount of cost assistance is also key to where you are geographically, because health insurance costs a different amount in New York than it does in Alabama. So it's pegged to the cost of the second lowest silver qualified health plan available on that particular state's exchange. It's only available for silver qualified health plans, and certain aspects of it are only available for silver qualified health plans. And if you fail to enroll in this program, you can get a tax penalty unless you qualify for a hardship exemption. And that hardship exemption is saying even with the subsidies, it would cost more than 8% of my household income to obtain health care. Next slide. So the subsidies have been incredibly popular and incredibly important for expanding healthcare coverage. In 2014, about 6.7 million individuals relied on subsidies to afford their health insurance. 4.6 million of these individuals lived in the 34 states where federal exchanges operate. By 2016, it's projected that about 13 million individuals are expected to rely on subsidies, so this is a huge chunk of the population. These subsidies don't just benefit the people who are receiving them. They actually improve the health insurance markets for everybody looking to obtain health insurance, because essentially you're getting a flood of healthy people into the markets who might not otherwise get health insurance. So it helps keep the premiums much lower. A recent brand study, which was cited in several of the briefs to the court, predicted that without the federal studies, unsubsidized premiums on the federal exchanges could be 47% higher. So the subsidies not only affect the individuals receiving it, they also affect everybody as well. Next slide. So the impact of removing these subsidies would have been huge. So about 6 million individuals across 34 states with federal exchanges would have immediately lost access to affordable health insurance coverage unless those states immediately switched to run their own exchanges, which would have been logistically very difficult at least. It would have also impacted Medicaid and CHIP enrollment by about 500,000 because there'd be fewer people trying to enroll in healthcare because they know they wouldn't be eligible. By 2016, 8.2 million Americans would have been uninsured due to this decision, and the individual markets would have had actually fewer enrollees in them than they did pre-ACA. So this would have really undermined the individual market. On average, the most reliable statistics suggest that annual premiums for individual plans in these states would have gone up 35%, or about $1,460 per person per year, which is a pretty hefty chunk of change. Next slide.
Well, can I just jump in there for a second?
Uh-huh.
Yeah, I just wanted to say that obviously all of these outcomes for the folks that are listening are all if nobody has taken any action, right, in terms of trying to offset all of these horrible things. So, for instance, the Supreme Court could have stayed its decision until the end of this insurance year. Congress could potentially have stepped in and done something to, to mitigate some of this. But indeed, all of these horrible things would have happened if nobody had done anything.
Yes, this is absolutely the doomsday scenario. It's true, Congress absolutely could have stepped in, although as was brought up in the arguments in front of the Supreme Court, I'm not sure if anybody has a lot of faith in the current Congress's ability to step in and fix anything right now.
That's right.
And like I said, the states that don't run their exchanges could have chosen to do so. And if people are interested after the presentation, we can talk about logistically what that would have required. So the impact of removing the subsidies wouldn't have just been felt on the individuals themselves. It would have been felt on the healthcare industry as a whole. So healthcare spending would have decreased by 35%, from $27.1 billion to $17.4 billion for the individuals who lose their subsidies. And this reflects billions of dollars less of spending in hospitals, on physicians, on prescription drugs. And this was reflected in the fact that not a single business group filed an amicus brief in support of the challengers in King. So for example, the Hospital Corporation of America, which is the largest healthcare provider in the country, filed an amicus brief in support of the government. This is really different than the 2012 healthcare case, where business was either split or largely against the ACA. Here it was very clear that the healthcare industry was saying that if you take away the subsidies, it could be potentially devastating and destabilizing to the healthcare industries in the states that would be affected. So this is notable because Roberts tends to think a lot about sort of business implications. And so it was considered that the fact that the interests of the industry were so strongly aligned with the interests of the government in continuing the ACA structure that it would have had an impact on his thinking. And we're going to discuss the impact of other amicus briefs on the court's opinion a little bit later. Next slide. So the impact on the states as well would have been huge. Here's a chart that shows how much each state that doesn't run its own exchange, or at least the major ones, because like I said, we're talking about 34 states. How many people qualify for the tax credit? What's the average tax credit in each state? Because remember, it's key to the geographic market, as well as how much they would have lost. And as you can see, these are some really big numbers. So this is a lot of money that was at stake. Next slide. So I pull up this chart of the geographic impact that King would have had, where anything that isn't dark blue, anything that's federally facilitated or state or partnership, could have potentially lost subsidies had King been decided differently. If you are really immersed in healthcare policy, as no doubt many of you are, you'll probably take a look at this chart, this graph, and think, this map looks kind of familiar because it maps out somewhat well to Medicaid expansion maps in terms of which states have chosen not to expand Medicaid and which states have chosen not to run their own exchanges. So you would have seen potentially this weird two-tier system where some states would have really had the ACA in place, would have had Medicaid expansion, would have had the subsidies, whereas in other states it would have been as if the ACA hadn't happened. So thankfully that is not the case, and everybody in the country can continue to get subsidies. So let's dive into the legal analysis itself. Next slide. So very famously, the Supreme Court on Thursday said that the language of the ACA does allow for subsidies on the federally run exchanges, not just the state-run exchanges. So everybody who's getting their subsidies can keep their subsidies. The decision was decided by a more comfortable margin than I think many people were predicting. It was 6-3, with Alito, Thomas, and Scalia being the dissenters, and with Roberts and Kennedy being what were seen as the swing votes to join the liberal half of the court. Roberts was the one who wrote the opinion. He famously wrote the opinion in Enfib v. Sebelius, the 2012 Supreme Court case. When he had written that opinion, that was a complete surprise that he was the justice who was going to be the swing vote, not Kennedy, and that he was going to write it. So it's speculated that he decided to write the opinion in this case because healthcare is now kind of, in a way, his legacy too, just as much Obama's, which I think is an unexpected chapter of his career that I don't think he would have anticipated. So let's talk about what exactly was at issue. The question at the heart of this case can be phrased in a couple different ways. So the main question is, does language empowering the government to offer subsidies to individuals who purchase qualified health plans through an exchange established by the state include both federal exchanges and state exchanges? So the practical question, the question that your mom is going to ask when she wants you to explain King to her, is, can the IRS allow individuals to receive tax subsidies for qualified health plans purchased on either state or federal exchanges? The legal question, the one that no doubt thousands of law students in the fall are going to be subjected to when they go back to class, is when interpreting a statute, do you go only by the plain meaning of the key provision that you're looking to interpret, or do you look at the statute as a whole, placing this language in context? Next slide. So to summarize the parties' arguments quickly, the challengers argued that the wording in the text of the ACA prohibits the federal government from providing subsidies to individuals if their state does not run its own exchange. And they got this from the key wording that these subsidies shall be granted for such individuals who purchase their insurance exchanges established by the state. That's the key. Those 4 words are the words that we were fighting over for the last year or so. And they argue that you need to use the plain language, the plain meaning of this language when interpreting the statute. So they say it's very clear what a state is. The federal government is not a state, and therefore an exchange run by the federal government is excluded by this language. The administration, on the other hand, argued that the wording of the ACA must be interpreted according to congressional intent, that Congress intended to provide subsidies to all lower-income Americans, and that when the federal government runs an exchange, it's acting for the state. And at heart, they were arguing that when you look at a statute, you can't just interpret the plain meaning of the words in front of you, but you also need to look at how it works with the rest of the statute and with other provisions. So next slide. So to start off with, the court gave us a tour of the ACA as well as previous efforts at healthcare reform, starting with the reforms in the 90s, which looked to minimize pre-existing condition screening, as well as premiums based on pre-existing conditions, but didn't necessarily push people into buying health insurance. They didn't have individual mandate components. The Supreme Court opinion also talked at length about the Massachusetts healthcare reform that happened in the early 2000s that really formed the blueprint for the ACA. They acknowledged, as I said, that previous efforts at healthcare reform failed when they prohibited insurers from screening out or charging enrollees higher premiums for pre-existing conditions without requiring individuals to purchase health insurance before they became sick. And this leads to one of my favorite terms in healthcare economics, death spirals. Because what happens when you make it so that people don't have, when you make it so that people can wait until they get sick before buying health insurance and they aren't going to be screened out and they aren't going to have to pay more, because people say, great, I'm going to wait until I'm really sick to buy health insurance because it's expensive. So only sick people buy health insurance. The problem is that health insurance works best when it has a very large pool of healthy people and only a few sick people, because essentially the healthy people are subsidizing the sick people. When your pool becomes weighed more to sicker people, you have to increase the premiums to cover the cost of the group as a whole. When the premiums go up, if you say, okay, you can't screen for pre-existing conditions, then more people will say, wow, health insurance premiums are going up every year. I don't know if I can afford it. I'm just going to drop this, and if I get sick, I'll just sign up for health insurance again, which creates this feedback loop of the healthy people dropping out, premiums getting raised, and then more healthy people dropping out until only sick people are in health insurance, and then it's not really an insurance scheme. So the court noted that the ACA sought to avoid death spirals by adopting 3 interlocking key reforms. So they did remove pre-existing condition screening and premium pricing, which has been an incredibly popular politically across the country. The ACA also requires individuals to either purchase health insurance coverage or pay tax penalty. So the idea is you can't free ride and say, okay, I'm only going to buy health insurance at the last minute when I actually need it. And then the ACA also provides subsidies to individuals with household incomes between 100 to 400% of the federal poverty level in order to make health insurance affordable. And so those 3 reforms work together to mean that the majority of Americans do have health insurance and are in the health insurance scheme before they get sick. Next slide. So the court then addressed the plain language theory. So it did acknowledge that the provision at issue, that the subsidies depend on part on whether an individual has enrolled in an insurance plan through an exchange established by the state. Again, that's the key language. initially suggests that exchanges established by the federal government are excluded from the subsidy program. They also acknowledge that elsewhere in the ACA, state is explicitly defined as each of the 50 states and the District of Columbia. Note that doesn't include the federal government. However, the court went on to explain that when you read the key language in the context of the broader statute, the meaning of the phrase established by the state is not so clear. Next slide. So the court noted that when you read this language in context, the key language becomes much more ambiguous. This is because several provisions treat the state and federal exchanges as interchangeable. For example, a provision provides that if a state does not establish its own exchange, the federal government shall establish such exchange. The court noted that this provision suggests that state exchanges and federal exchanges are equivalent, that they must meet the same requirements, perform the same functions, and serve the same purposes. They noted that other ACA provisions also assume that the subsidies will be available on both state and federal exchanges. For example, there's a requirement in the ACA for all exchanges to create outreach programs to distribute information about the availability of the subsidies. That wouldn't really make sense if the subsidies wouldn't be available on the federal exchanges. Next slide. So the court decided that it needed to interpret the key provision itself, turning to the broader structure of the ACA to determine the meaning of the language. This is a little bit unusual because usually when statutory language is ambiguous, the courts use the Chevron test to evaluate the validity of the governmental agency rule by interpreting whether the agency has interpreted the statute in a reasonable manner. But the court said Chevron wasn't the appropriate test to use here because this question was essentially too important. They said Congress wouldn't have implicitly delegated such an important question to the IRS. They would have explicitly delegated it. And they also noted that the IRS does not have a long history of healthcare policy, so they thought it would be very strange for Congress to delegate such an important healthcare policy question to the IRS. Next slide. So the court found that the statutory scheme compels us to reject the petitioner's interpretation because it would destabilize individual insurance markets in any state with a federal exchange and likely create the very death spirals that Congress designed the act to avoid. They noted that 87% of people who bought insurance on a federal exchange in 2014 did so with subsidies. Without these subsidies, almost all of these individuals would become exempt from the individual mandate because they wouldn't have affordable health insurance available, which would severely destabilize the health insurance markets in states with federal exchanges. They thought that it was implausible that Congress would mean for the ACA to operate in this manner because this would be a really fundamental part of the law, this idea, okay, if you don't run your own exchange, we're going to basically jeopardize your entire health insurance industry. And Congress doesn't stick all of these really important details in subsections of an act. They would put that front and center. Next slide. So, like I said, 6 justices signed on to the majority opinion, saying that Congress could not have possibly intended for the subsidies to only be available on state-based exchanges. There were 3 justices who felt otherwise. Justice Scalia wrote the dissent, and he was joined by Justices Thomas and Alito. I suggest that if you are not a Scalia fan, you read this because he is quite irate, although perhaps not as angry as he was then in the marriage equality case the next day. Last week was not Scalia's finest week. So he argued that the majority conclusion was quite absurd and that words no longer have meaning if an exchange that is not established by the state is established by the state. So he is clearly not a fan of the majority opinion and clearly believes that you should just read the language according to the plain meaning. However, it's a dissent, it's not a majority opinion, so obviously it's not the law of the land. Next slide. So what's the legal impact of King? So millions of consumers across 34 states who rely on the subsidies to afford their healthcare insurance get to keep their access to health care, which is a huge, huge, huge win. And in a way, it's an even better win than we expected, because everybody thought at best that this would be decided by using the Chevron test. And when the court rejected the Chevron test, it actually strengthened the protections around the ACA. If the court had used the Chevron test, then potentially the IRS in the future, especially if it was under a more conservative precedent, could have chosen to interpret the language differently and perhaps pulled the subsidies from the federal exchanges. But because the court itself interpreted what the ACA meant, there's no way to change that interpretation without congressional action. So we can rest comfortably that the subsidies are here to stay on the federally run exchanges, which is a huge win for everybody. I'm now going to turn the presentation over to Scott to discuss the unique role that the amicus briefs played in this opinion.
Great, thanks, Carmel. Thank you for going to the next slide as well. There we go. So I want to tell you all a little bit about what amicus briefs are and the role that they played then in this particular case. So first of all, the word, amicus curiae, is Latin for friend of the court. And you can kind of see in the word, right? Amicus kind of sounds like amigo. So that is what it means. And actually, we oftentimes just call it a friend of the court brief so that everyone can understand what those words mean. And there's actually also, you know, some people say amicus, some people say amicus. And I don't know that one of them is more right than the other. So that's what an amicus brief is. And it's when a person or group who is not a party to some type of appellate level proceeding, and they have a strong interest in the outcome of that proceeding, they will submit a brief. They'll petition the court and ask for permission to submit a brief, and then submit a brief with the intent of influencing the court's decision. So that is what an amicus brief is designed to do. It is a way of bringing relevant information to a court's attention and ensuring that the possibly broad effects of a court's decision will not depend solely on the arguments presented by the parties directly involved in the case. Because those parties may or may not have, you know, a good grasp on all of the different implications of the decision, and then they're serving, you know, the specific interests of their client. So that is the role of amicus briefs. And Supreme Court Rule 37 states that in part, such a brief is supposed to cover relevant matter not dealt with by the parties, which may be of considerable help. So that's actually one of the tricks in writing an amicus brief, is ensuring that you're not duplicating what the parties' briefs are doing. You're not just supposed to be like making the same arguments and basically adding numbers to how many people are making that argument before the court. And it's supposed to be matters that are not dealt with by the parties, and it's supposed to be helpful to the court. Can we go to the next slide? So in this case, the amicus briefs actually, I think, played a fairly important role. You know, it's not always the case, I think, that the amicus briefs play an important role, and I think it's sometimes hard to tell if the amicus briefs have played much of a role. On occasion, an amicus brief gets cited in the court's opinion, and so then it's pretty clear that that amicus brief was weighed in or changed their thinking a little bit. But that doesn't happen all that often. For those of us that write these types of briefs, that's a huge feather in your cap if you actually get the court to cite the amicus brief that you wrote, helping the court out. So in this case, there were 21 amicus briefs in support of the petitioners and the plaintiffs in this case. So the petitioner refers to their posturing before the Supreme Court, and then plaintiffs is what they were below. And 34 briefs supported the government's position. And so I just want to say something about those numbers. There's been criticism in recent years about the number of amicus briefs that are now filed before the Supreme Court. So it used to be that there would just be a fairly small number, and it has grown and grown and grown over time, so that now there are a lot of briefs presented. And I think some of the justices, at least, would like to see fewer briefs, in part because they, or really their law clerks, read them all. But it's also, there's some question as to whether, a decision should be made sort of taking into account all of these other things that people are placing before the court. In any event, the other factor that weighs into the validity or effectiveness of an amicus brief is that the court does not usually it's not designed to make policy judgments, right? That's for the legislature to do. The legislature gets to decide what is the best course of action to take on a particular issue or topic. And it's the court's job, ostensibly, to simply interpret whatever decisions were made, whatever was written down in the laws, and wherever those policy decisions were made. However, in this case, and I would actually say probably in more cases than justices or judges are willing to admit, the policy arguments played a pretty important role in determining the outcome of the case. So first I'll just say that I don't think, as we see from the majority opinion from Roberts, and then the strident dissent from Justice Scalia, which was supported by 2 other justices, the answer is not necessarily just in the words. It's not necessarily in the statute. If it was, then the case probably never would have made it to this level. And so while Roberts made arguments about how this would be applied, or that the fact that when you interpreted this provision in other parts of the statute, when the same phrase appeared, that it would have these strange consequences, well, Justice Scalia was able to come back and do the same thing, using the interpretation that Roberts was putting forth in his majority opinion and saying, well, but this doesn't make sense if you do this. So the answer is not always in the words of the statute. And so as Carmel said, the policy judgments actually can play an important role here. One of the things that usually what gets you to a policy decision is that there has to be some finding of ambiguity. If the statute is plain on its face, well, at least some justices, the more traditional, and they're called textualists, would say then the inquiry should go no further. If you can read the words and understand what they say, then you should just apply them. In this case, and usually I guess the general rule is that if you find ambiguity in what the provision says, then you can look to other things to try to figure out what that provision means. And one of the things that you can look to is the rest of the statute. There's several things that courts could look to. They can look to the legislative history. That's one that they tend not to rely on as much. They can look to what looks like the intent. What was the intent of the act? So there's several different things that they can look at to determine what a provision means, but they generally don't get to that inquiry unless there's ambiguity in the provision before the court. So it's interesting in this case because one of the things that Justice Roberts did was he said, well, actually looking at the context of the statute created the ambiguity. So it kind of sort of shifted a little bit around the balance or the order in which those two things would come. But that ambiguity then allowed the court to bring into its opinion what the policy was behind the statute, what the intent was, how Congress had gone about creating this change, and the three-legged stool that people refer to when they talk about the three-pronged approach of the ACA. And that was incredibly important. And then the other thing that I think is really important about the amicus briefs is that the dire consequences that were discussed in many of the amicus briefs, and I would say that most of the briefs, or a lot of the briefs supporting the government, talked about some aspect of the dire consequences that would ensue if indeed the subsidies were taken away from everyone on a federal exchange. The court decided that, and I think that the amicus briefs helped the court decide that Congress could not have intended this result in this case, that they would not have written the statute in this way if that was going to be the outcome in this case. So next slide, please. So I'm going to talk to you now a little bit about the amicus brief that we wrote, and then I'll hand it back to Carmel to talk about the amicus brief at the Center for Health Law, Policy, and Innovation. Health Law and Policy Innovation, sorry, I almost got that wrong, wrote in this case. So Lambda Legal wrote a brief on behalf of ourselves, the Asian and Pacific Islander Coalition on HIV/AIDS, or PICHA, the Black AIDS Institute, Gay and Lesbian Advocates Advancing LGBT Equality, GLAD, the HIV PJA, which I'm assuming you're all familiar with, NASM, the National Black Justice Coalition, NMAT, and Latino Commission on AIDS. And as I described to you sort of what the purpose of the brief was, or what it was arguing, you know, maybe understand why we had these particular groups on here. So our brief really talked about the devastating impact that withdrawal of ACA subsidies would have on people of color, in particular, living with HIV, and on higher risk communities. And I think that it's easy for us to forget. I think a number of people on the phone are probably advocates around HIV/AIDS, and we are so well versed in these arguments and in an understanding of how access to care can really make a difference and really possibly turn around our efforts with respect to the HIV/AIDS epidemic. It's easy to forget that other people don't necessarily have that information. So part of our goal here was to simply put before the court this information about how once you are treating people living with HIV, that it results in improved outcomes for those people. It results in a lowered risk of transmission, and just all the effects that it will have down the line, particularly to low-income Americans, and then the significant problem that is still being experienced by communities of color around the disproportionate burden when it comes to HIV and substantially worse health outcomes. And so then that's how we sort of laid out the argument for why this was really important. But this is also a trick of writing amicus briefs, is that generally you don't just say, hey, there's this thing I want you to know, court. There's this other piece of information you consider. Usually you're trying to then take it and make some type of legal argument as to why the court should take that information and make a different decision. So you have to kind of fit it into a legal framework for the court to be able to rely upon it. And so in our brief, we argued that there were equal protection problems. We didn't really talk about an equal protection violation because we didn't know that we could convince the court that it rose to the level of an equal protection violation. But we did think that it was significant that they'd be able to see that by interpreting the statute the way that the challengers wanted, they would set up a problem in terms of treating two different groups or two groups differently for no good reason. And what this quote here says is it would be because the level of government that sets up an exchange in a given state is irrelevant. So whether the federal government or the state government sets it up doesn't really matter in terms of the people accessing care through that exchange, and it's invisible to those consumers. And so surely, we said, an irrational criterion on which to impose such a draconian consequence of making health insurance unaffordable. So that was the Lambda legal brief, and I'll turn it over to Carmel to talk about the Center for Health Law, Policy, and Innovation brief.
Thanks, Scott. So Chilty also helped spearhead an amicus brief. We had about 43 advocacy organizations that serve populations that are deeply affected by the availability of federal subsidies under the ACA sign-on. The majority of these organizations serve the needs and interests of people living with HIV, but not exclusively so. And so what we did was we tried to put a personal face on what would be the human cost of striking down these subsidies. So we had the individual stories of 4 individuals who were in states with federal exchanges that were able to receive health care because of the subsidies, including some really powerful stories, like the story of a mom who got health care insurance the minute that the ACA opened up individual markets and she received the subsidies. Then a month later, had some pain, went and got screen, found out that she had ovarian cancer, which they caught early enough only because she had health care coverage, and then got tested and found out that she had a syndrome that predisposed her to breast cancer as well. So the ACA literally saved her life. And if the subsidies were struck down, she would no longer be able to access that health care. So we also tried to tie it to the fact that there's so many public health issues that really can only be addressed by making sure that everyone has meaningful access to health care, by making sure they're covered through insurance, either through public payer programs like Medicaid or through private health insurance with the subsidies. And we, to illustrate that, use the example of Massachusetts, which has very high levels of healthcare coverage as compared to the rest of the country when it comes to HIV, and discussed how with the continuum of care, when you're plugged into the healthcare system, we have a good chance to bring your viral count to be undetectable, and that has really great public health implications as to whether or not you can pass on HIV to loved ones, and just shows that with better healthcare coverage, you have improved public health outcomes. So it's interesting because certainly Lambda and Chilpi work with very similar organizations and are very much immersed in some of the same work. That's why we often collaborate, for example, on projects like this webinar. But both briefs come from a very different point of view to try to inform the court as to the ramifications of ruling one way or the other. So Scott, I'm going to turn it back over to you.
Thanks, Carmel. And so I'll just wrap up this section actually by saying that I think in the end, what really happened here was the court realized that if they allowed the challengers to win, that they were going to create serious problems in different aspects of the country for people, like we discussed in our brief, people living with HIV, people living with other health conditions, as well as for the business side of it, the healthcare industry, and that for them it didn't make sense to throw everything into that kind of chaos. And I think that's really the basis for this decision. Yes, they have to write a legal decision that then supports that. And they did talk about, hey, you know, Congress would not have done this. This could not have been their intent. In the end, I think it was really, it was a policy-based decision about the consequence of this. And I think that the amicus briefs across the board, not just ours, not just the Center for Health Law and Policy Innovation, but a number of amicus briefs laid that case out for the court and made them understand the consequences here. So we're going to go to the next slide. We're going to talk a little bit about the next steps in post-King advocacy. And I would say that this is one section that got to be a little bit shorter and easier on this webinar, because if we had lost this case, well, then there would have been a lot more to talk about and a lot more things that needed to be done. Not that there aren't things that still need to be done, and not that they're not very important. So I'm going to start talking about them right now. So first of all, meaningful healthcare access is still not guaranteed for all Americans, even though we have prevailed in this particular case. It really just kind of puts us back on track and doesn't get us all the way there by any means. And the first thing that we really need to do, and I think everyone on this call is probably aware of this, is to expand Medicaid in the 22 states that currently have not expanded their Medicaid program. So as I think everyone probably knows, states are not required to expand their Medicaid programs to all individuals under 138% of the federal poverty level. That is the Medicaid expansion. 28 of the states have done that, but 22 of them, and as Carmel showed in that map earlier, it is many of the same states that did not run their own exchanges. We need to make sure that there is Medicaid expansion in those states. Millions of Americans across the 22 states are still denied health care access because they are either too poor for the subsidies, and they are too for lack of a better word, rich for the traditional Medicaid. And so they're kind of stuck in this no man's land. And so I think one of the important things we need to do is advocate to continue putting pressure on the state policymakers to accept Medicaid expansion in every state. And we know that this is going to be a bit of a battle, although Social Security, the Medicare program took many, many years before Arizona finally got on board there. So I'm hopeful that all the states will get there eventually, and it may just take a little bit of time. I know that one of the things that's kind of being debated right now is, well, do we hold the line and force states to accept all of the provisions of the Medicaid expansion, or to what extent do you engage in the waiver process and allow states to modify and have a slightly different standard set up for when someone is eligible for Medicaid? And as you can imagine, there are good arguments on both sides of this, right? We want every state to expand their Medicaid program, so if we can make it easier for them to do that, well, then that seems appealing. At the same time, and I kind of, I think, fall down on this side of it, I'm very concerned about creating different standards in different states in the country, because I think that we end up reinforcing and exacerbating the existing healthcare disparities in those states. And so there's partially a political calculation being made there, and then there's a practical side to this of trying to get everyone into care. But however we do it, we need to get Medicaid expanded in every state. The next thing that we have here on our list is to ensure that consumer protections and regulations are meaningful, that they're actually protecting the consumers that they are designed to protect. And there's been some reluctance on the part of federal regulators to implement some of the regulations that we think are necessary in order to really ensure that people are getting access to this care and that it is affordable, and that it's not excluding any particular groups like people living with HIV. And I think there are various reasons for that. Some of it may have been due to the uncertainty of the outcome in this case. But I think there's other reasons too, which again have to do with politics of it. And, but in any event, I think we need to continue to push for them to have real regulations with teeth to make sure that people are getting the kind of care that should be available under the ACA, which is the next point we have here, that that they are responsible for ensuring the fulfillment of the promise of the ACA, which is, as title says, it's actually the Patient Protection and Affordable Care Act. And so two of the things that it should do at least is protect patients from these practices that make it difficult for them to remain insured, and to keep that healthcare insurance affordable. And so it's going to be important that we have those regulations in place. And it'd be important, too, that they're federal in nature. Again, we don't really want this to be different state by state. We want there to be one standard across the country so that we don't end up with greater disparities in the kind of healthcare that people receive simply because they're living in New York versus living in Alabama. So, so that's number two. And then the third thing, and I think a number of people on this call will also agree with this, is that we need to make sure that the robust Ryan White HIV/AIDS program is still in place and that it continues even after reauthorization, whenever that comes. So for people who aren't aware, there's been kind of a strategy around holding off on reauthorization while we kind of see how everything starts to play out in terms of the Affordable Care Act, and also because I think there are some concerns that we could end up, getting less funding. And so right now with flat funding, it's actually maybe not the worst thing for us to not push for reauthorization, although I think that calculus may be starting to change. But when it happens, however it happens, we need to make sure that Ryan White HIV/AIDS program is still robust. For one thing, there are a significant number of people, including undocumented immigrants, that are not covered under the ACA. And so we need to be providing a safety net for those folks. just as we were prior to implementation of the Affordable Care Act. And then the other thing is that people who are enrolled and facing other challenges in terms of accessing care or just other challenges in their life, that the wraparound services that the Ryan White program provides are very important to those folks and to ensuring their health in the long term, which we know is also then a public health issue, et cetera. So, and actually this is another good example of where Massachusetts comes into play here. So Carmel talks about it, actually Justice Roberts talked about it in the opinion. And the fact is that one of the reasons Massachusetts is doing well and has positive outcomes or better outcomes in terms of people living with HIV and AIDS is that the Ryan White funds are still there. And so the importance of maintaining them so that we can see those kinds of results across the country cannot be overstated. And that is, I think, takes us into our questions. So do we have any questions in the queue?
Hi, yes. Thank you so much, both of you, for all this information. It's been fantastic, especially for us non-lawyers here on the webinar. So just a couple quick questions. We have time for about two. So sort of like we talked about, the decision by SCOTUS sort of effectively ensures that the ACA is here to stay and that subsidies are here to stay, but there does continue to exist so many challenges for access to care and cost of medications, specifically for those living with HIV. So there's some questions here about sort of the legality of a couple things. One of them is dropping HIV medications from formularies sort of halfway through the period of an individual in that marketplace plans, and is that legal, and what does that look like? And then also just curious about maybe the impact that this decision and generally where the ACA is headed, sort of maybe what the landscape for 2016 means in terms of the price for premiums and maybe possibly those kind of skyrocketing. Do either of you want to speak to either one of those questions?
So Carmel, you might be better equipped to talk about both of these actually. So I'll turn it over to you. I mean, certainly the regulations in terms of the stability of the formularies.
Yeah. So I first want to put in a plug for a program we run called Speak Up, which you can access at hivhealthreform.org. If you or consumers you know are experiencing issues in which your HIV medications are being dropped from your plan halfway through the year after open enrollment is done so you can't switch, go to Speak Up, fill out the form so that we can document it and we can bring it to the attention of HHS. That's going to be an effective way to put political pressure on them to start working on regulations forbidding this practice, because right now there aren't any federal protections around changing formularies part of the way through the year. However, if it is a qualified health plan, it needs to meet the essential health benefits package, and it needs to cover a certain amount of medications per class of drugs. So if they're dropping all HIV medications, then that's certainly something that is against the ACA and against the regulations. If they're dropping one specific one, I would say go to Speak Up, fill it out so that we can talk one-on-one and figure out what to do from there. So in terms of what's going to happen with the premiums next year, that's a little bit of guesswork. I think in some ways it might actually help the premiums, and that insurers are going to be less worried that this program is going to go away. So they won't feel like, okay, well, we need to make a profit right now because who knows if this will be around next year. I will also note that we are in a period of historically slow growth in healthcare spending. That since the ACA passed has been the first time in about 2 decades that healthcare spending has not grown by leaps and bounds each year. It is still growing, so you will see your premiums go up, but they'll go up by much less than they would have if we were talking about the 90s or even the early 2000s.
And I'll just say on the the formulary piece that, I mean, it seems like common sense, right? That if a market is going to operate efficiently and well, which is the idea of the Affordable Care Act, is that you create a marketplace in which all of these things play out. But in order for a market to operate well, there needs to be good information, and people need to be making their choices based on information that is stable. And if it's changing midway through the year, well, then how do people make a good choice about which plan they're choosing to purchase? So it seems like a common sense thing, but sometimes common sense things still have trouble getting through certain business interests. And I just want to say that I do think that many plans, if not most plans, have some type of waiver process. While it is cumbersome and nobody wants to have to do it, I think that if an HIV medication is dropped from your plan that you are taking, I think that you can, and you're locked in there for another 6 months or whatever, you can apply for a waiver so that you can still continue taking that medication.
Great. Thank you both, Carmel and Scott. So in the interest of time and being respectful of that, we are going to wrap up today's webinar. If you do have any questions that you would like to reach out to us and get answered, you can see both on the former slide and this slide some contact information for both Lambda Legal and Harvard. So you can get this information on the slides that will be available to be downloaded in the follow-up email that everyone will receive after this webinar. You'll have a link there to download the slides from today's webinar, and you can reach out with questions that you might have. So I just want to thank everyone for joining us today, especially Carmel and Scott. The information that you guys provided was absolutely fantastic, and we so appreciate your time and your information. So with that, we will wrap up. Thank you so much, everyone, for joining us, and have a great day.
Thank you.
Thank you.